Think forward. Think Research Channel.
I'm Aaron Black for the Copyright News Network, reporting outside the Copyright Court. The following is a real dramatization using real actors talking about real issues of real copyright law. The characters and situations are not real. It's fiction, folks. Like me, I'm not a real reporter, but I'm playing one on television. Want real legal advice? Call a real lawyer. We're just giving you a little something to think about, all right? So let's go now to the Copyright Court.
All rise for the Honorable Judge Wright.
We're here for Neil Younger versus Virginia Teacham. Do we have a plaintiff?
Oh yeah, I'm Neil Younger, but most people call me Wawa because I'm a musician. You know, the electric bulbs. Everyone was grooving to our sound in the summer of love.
Are you pro se, Mr. Younger?
Maybe, as long as it's liberal.
She means, are you representing yourself?
Thank you, Miss Teacham. I take it you're also pro se?
Yes, Your Honor, and it's Professor Teacham.
Okay. Mr. Younger, what is your complaint?
Well, I'm watching TV the other day, and suddenly it's a blast from the past, and I'm hearing our band play Mendocino Love Child. I said, whoa, what's that? And it's this professor man using our hit song, Our Vision Man, as part of some whacked science show. And I don't want to sound all establishment, okay, but bread should change hands here, as in royalties. Isn't that right, Judge?
I object. Mr. Younger is entitled to nothing from me.
And why do you think that, Professor?
Because it's for educational purposes, Your Honor.
Professor Teacham, what class do you teach?
I do a series of lectures on analytical chemistry. We use the song over our opening titles. I find it sets just the right mood for the lectures.
Far out.
Professor Teacham, Mr. Younger, I'm ready to rule on this. Professor, you owe royalties for your previous use of Mendocino Love Child. And until you come to an agreement with Mr. Younger, you will no longer use this music as part of your lectures. Am I clear?
I'm not right?
No, I'm right.
You're Judge Wright.
And I know copyright. Fair use is a principle of copyright law that says that it is not a violation of copyright to use copyrighted material for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. To decide whether a particular use is a fair use, the court considers all the facts and analyzes them relative to 4 factors, which are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the potential market for or value of the copyrighted work. No one of these factors is either necessary or sufficient for a finding of fair use. It's more like the concept of family resemblance in Ludwig Wittgenstein's philosophical investigations.
Huh?
Let me help contain the confusion here. I have with me Dr. Hausman, a professor of law at a big school in one of those small, tiny states. Professor, could you explain the judge's ruling?
Of course, Aaron. Fair use applies to some, but not all, cases of instruction in the classroom. For instance, if you were teaching a class on the history of music, you could use Mendocino Love Child as an example. Or if you were giving a lecture on social movements of the 60s, it would be appropriate to use the song.
Yeah.
But for an analytical chemistry lecture, no.
Professor Hausman, let's write this out for our more visual learners.
Of course. Please watch the screen closely. Fair use favors educational uses of copyrighted materials, but just because a use is educational doesn't automatically mean it's okay under fair use. Once an image or music is recorded on tape or film and distributed outside the classroom, it's no longer safe to assume that fair use still applies. Use of only part of copyrighted material may still be a violation of the copyright. Of course, I'm just an actor, and this script does not cover all aspects of copyright law.
So you're saying talk with an attorney or your school's legal department before you use somebody else's material, or at least be sure you have permission from the artist.
Exactly. If you're going to copy, check the copyright.
Permission of the artist. Thanks for the pen, man. You know, you could have just asked me.
Yes. Well, I thought you were dead.
No, that's Jerry Garcia.
Oh.
You know, so many of these things just require a little communication, don't they? You'll see that again in our next case, which, by the way, wouldn't really be in a court at all because it's just a discussion of issues. But who cares? We're having fun with this. And also, we rented the room for the whole day. Christy Spielberg is a television producer at a large private university. Her job is to record lectures and prepare them for broadcast and web streaming. Dr. Ivana No is a prominent professor at the university and a nationally known lecturer on all things fabulous. They're in court today because Dr. No refuses to sign a talent release form for her recorded lectures, creating legal concerns for Ms. Spielberg.
Dr. No, may I call you Ivana?
Of course.
Thank you. Now, what concerns do you have that prevent you from signing these forms?
Well, of course I understand that I need to give permission to broadcast my lectures. But this document they've given me to sign is incomprehensible and really, really boring. I believe it was written solely to trick me into signing away the rights to my intellectual property.
What?
Who knows what infamous plan lies behind this? Perhaps they'd simply like to replace me with a two-dimensional video lecture. What a tragedy for my students.
I understand your concern, Ivana, but you know how attorneys are. They like to cover every possibility. Ms. Spielberg, what is the intent of your talent release form?
Well, we want to make sure that we can use what we film. It's an expensive waste of time if we can't, you know.
Well, what about this any and all media part?
Please, Ivana, let's stay inside our roles here. Ms. Spielberg, what about this any and all media part?
It's all about change, the future of media.
Do you mean like streaming on the web?
Well, yeah. If we have some great lecture from 5 years ago, say, we weren't thinking about streaming. Now we are. So we want to be able to get our material out there in whatever format is most popular.
This is about more than the medium for transmission. This is about taking my soul, my essence, for unnamed but possibly degrading uses.
Huh?
What about my professional integrity? What about money? What if I see myself on sale at the video store? I will have signed away the right to receive additional compensation. The university might balance its budget on my back.
So the question is, does the university make a practice of selling the faces of other faculty to commercial productions or using faculty images in embarrassing ways?
No.
I think not.
Okay then. The other issue is Dr. No's intellectual rights. Based on what I'm reading here, the university would own the recording itself, but you, Ivana, would retain all rights you otherwise own. So you're giving permission to tape and air a lecture, but you're not giving up ownership of the content. However, you do have the right to put the restrictions on the use of your recorded lecture.
What? My boss is so not going to agree with that.
And it's so not your boss's place to dictate someone's rights. Think about it. If Dr. No's ability to make an income from public speaking is affected by the popularity of your videotape, she would have to change her fabulous lifestyle. So, she might very well request amendments to the release form or refuse to be taped altogether, and that would be her right.
So do we have to accept anything she writes into the form?
Of course not. You can refuse, then she can refuse, and the whole video project becomes refuse.
Well, naturally, I don't want to be too hasty on this. Perhaps I could have the university's attorney explain it to me before I sign. Is that Brad Pitt look-alike still in the legal department?
Why, yes, he is. Let's go see him together.
Okay, great. Thanks for coming in. What a weird day. Will it never end?
Just one more set, Judge.
You know, I'm not getting paid any extra for this either.
It's rough on the front lines of the law, as our fictional Judge Wright is finding out. The next non-case on our calendar is State University versus the Educational Program Broadcasting Consortium. State U videotapes lectures, then sends them to the EPBC for broadcasting. EPBC demands the university sign a copyright clearance form that says that State U has cleared the copyright on all copyrighted material used in the program. This puts the burden of any copyright issues on State U as the producer of the videos. Diana Shores, head of the video production for State U, is about to speak.
Your Honor, State University does not want to sign this copyright clearance form because we do not want to be held responsible if someone sues the EPBC over the program.
Sounds lame to me. Aren't you the ones producing the program? Aren't you responsible for the content?
Yes, but we aren't the ones airing it.
That's true, and someone might very well sue EPBC. But why would the consortium even consider obtaining programs from you if you can't guarantee that they're legal?
Okay, that's a good question.
I have lots more good questions. When your people tape a lecture, do they make sure that the speaker has permission to use any copyrighted material that's included?
You mean?
I mean any music, artwork, photos, basically anything that's not the lecturer's original material.
Of course we ask the lecturer to sign the clearance form, but that person may not understand what it means.
True. You should explain copyright issues if necessary and ask for a copy of the written permission to use it before making a videotape. And if the professor starts waving the fair use banner, tell him to forget it. It probably doesn't apply, and you will need permission to use the material. Ms. Shores, please approach the bench. Look, I don't want to embarrass you, but you seem a little young to be a department head. How old are you anyway?
35. It's my moisturizer.
See me later. That's it then. There's no ruling here, because this isn't the way a real court works. But I do have some real-world advice. The fact is, broadcasters are not going to take on liability for a program they didn't control. So play by those rules if you want to be in the game.
Dr. Hausman, could you sum up the judge's comments for us with visual aids?
Certainly. The party responsible for producing the program is responsible for clearing the copyright. This means whatever copyrighted materials are used in the program, but were not made especially for the program.
Great. That really clarifies things. I'm Aaron Black for Copyright Court. Good night.
Wait, is this my only line?
Get a better agent. Good night, everyone.
Well, thank you, Judge. And thank you for watching. Please enjoy our credits with copyright cleared music.